the credit. One case, Lalu Prasad versus State of Bihar, also we have discussed. And with that, chapter 5 we have finished. Now today I'll start next chapter, chapter number 4 that we have left, and it is on the accomplice. Accomplice, approver, Sarkari Gawa, Sultani Gawa, these are the some of the names that we can use. So basically, who is approver? Approver is the person who was the accomplice, who took part in the commission of the offense. Then the question comes, then when he himself is an offender, why he is on the in the evidence list, in the witness list? And the simple answer to it is, when there is no direct evidence and it seems to the prosecution that it would be difficult to prove the case against the just hello. And so, just to secure the prosecution, just to secure that the person who committed the crime is punished. So, not the main accused, but the accused that took part in the commission of the crime, subsidiary as an accomplice person, he is pardoned, because when in the charge sheet his name is there, he cannot be the witness against himself, and so he is pardoned. I think you have heard in many movies and many serial and in many other, you know, documentary, that aap sarkari gawa ban jao, to be a government witness. And so the main reason is to make the prosecution case strong. Only then a person from accomplice to become an approver, the pardon is given to that person under the CRPC and that thing. Now this, I think accomplice and other thing also you are aware, because many time I have used these words. The main controversy or main important thing that we have to discuss under this chapter is that there are two contradictory sentences, seems to be contradictory sections. One is section 133 and another is section 114 clause B. And when we read section 133 that talk about accomplice, it says an accomplice shall be competent witness against an accused person. So the first portion of the section 133 is very clear, and it makes that accomplice is a competent witness. Accomplice is a competent witness against the accused person, though he participated in the crime, but because he is not on the trial, he has been pardoned by the authority, now is an approver. He became a competent witness by virtue of section 133, as such, because he is on not the trial, but the section 133 recognized this fact. And then the second portion of section 133 is A conviction is not illegal merely because it proceeds upon the uncorroborated testimony of accomplice. The question is that up to the first portion there is no problem. Key accomplice is a competent witness. The problem arises on the second portion of the section 133, and that is, can the testimony of the accomplice be the sole basis of conviction of a person? And here comes some doubt that the person who took part in the commission of the crime, he was the friend of the offender, and now just because of pardoning, he is giving the testimony. Now he is not the friend of that person, he cheated that person, and on the prosecution side. And so it is unreliable person. Second thing is that maybe he is correct, that these are the two persons who took part in the commission of crime. But suppose in the meantime he thought that this is a good opportunity, and along with these two main offender, just include two other name also, to which the accomplice has the enmity, dushmani. And now there is no procedure by which we can separate out that those two persons whose name accomplice is saying, to save those persons. And so there is difficulty. But the law in the section 133 is clear. The question that comes in our mind, that can the testimony of an accomplice is sufficient for conviction of a person? Section 133 says that in law there is no problem. It would not be illegal if a person is convicted on the uncorroborated evidence of the accomplice, uncorroborated testimony of the accomplice. So there is no legal rule that testimony of the accomplice should be corroborated, कि उसको दूसरे evidences के साथ corroboration होना चाहिए. And then comes to the another section, section 114 clause B. Section 114 says that court may presume, and if you remember that when we discuss section 4 have three types of presumption: may presume, shall presume, and conclusive proof. Court may presume existence of certain fact. Section 114 I'm reading. The court may presume the existence of any fact which it think likely to have happened, regard being had to the common course of natural event, human conduct, public and private business in their relation to the fact of the particular case. And this section 114 even we will discuss in the next chapter also. So in the natural course, when something that used to be done in that manner, two strange person found in a hotel room, so inference can be drawn that there is some relationship between them. And so the court may presume, but it is not duty bound. And in this, the illustration be that an accomplice is unworthy of the credit. Why unworthy of the credit? Because वो तो दूध हाथ क्या कहते पाक साफ नहीं है. He was the accomplice in the incident. He took part in the commission of the crime, and now he cheated his old friend, and on the prosecution side, so he is unworthy. थोड़ा सा unworthy तो है. And unless it is corroborated in material particular, so the court may presume that an accomplice is an unworthy of credit unless he is corroborated in material particular. Section 114 say that court presume कर सकता है, may presume that an accomplice is unworthy of the credit, and corroboration is required. And now here the question is that what is the true cause? And after reading section 114 clause B and section 133, we can reach at a conclusion that as such, the testimony of an accomplice can be the sole basis of the conviction. There is no illegality in it. But there is a rule of prudence. That rule of prudence required that the testimony of the accomplice should be corroborated in material particulars. And corroborated in material particulars means if he said, if you tell a story that how this all these things happened, so this story has to be, some portion has to be corroborated with some material particulars. And unless it has not been spotted by material particular, in that case also, if judge convict the person, that would not be illegal. But the rule of prudence require that it must be corroborated, because there is always you know this cardinal principle or the heavy burden on the prosecution, that person has to be uh, you know he has to be proved guilty beyond reasonable doubt. So the rule of the prudence required, but if in some situation the court consider that okay, there is no need, in that case also, because he is an accomplice, he would this conviction would not be illegal by virtue of the section 133. Now, there are three cases on it to understand that what is the true meaning. And as I said, that the true meaning of these two sections is that it is the rule of prudence that the testimony of the uh, accomplice has to be corroborated in material particular. It is not the rule of law; it is rule of prudence. And so, in these three cases, there is at the length the discussion, because in these three cases, the accomplice was one of the main important evidence, the testimony of the accomplice. And so the question comes that whether it has to be corroborated or not, and how it has to be considered that it was corroborated. In these two cases, the first case I'm taking is uh, this Ravinder Kumar versus State of Haryana. Very simple and interesting case. Ravinder Singh versus State of Haryana, AIR 1975, Supreme Court 8556. What happened in this case? That Mr. Ravindra Kumar, who was the accused, and he was married, and he is in the Air Force. In the Air Force, he has his friend also, that is accomplice in this case. And this Ravindra Kumar, was in love with some another girl. He developed in love with some another girl, and this another girl want to marry Ravindra Kumar. So he went to his village, and then he went to his uh, in-laws house and said that you know send my wife, that means that to the father-in-law to the his wife. And then because of the some family function, the wife was not sent with the accused. Later on she sent to the accused. And then you know he want to convince his wife that please divorce me, etc., but she was not consented. And then they make the plan that they will kill this wife. Okay, so they are coming with the train from this place, that is Sisna, to the, yes, just give me 1 second. uh, to Sirsa. Okay, and during near Rewadi junction, When they deboarded the train, they changed the train from Rewari to the Sirsa side. They, in the compartment, there were only 5 person. This accused and his accomplice, they, put the acid on the wife and then throw the wife from the running train. After that, the wife was found on the railway track, and some person, admitted her to the hospital. There also she made one two statement, and after that died. Then, when the train reached at the Bhiwani, this person deboarded the train, and then the ticket collector, uh, caught him that show me your ticket, and he was without the ticket. Then what happened that this person even you know purchased the ticket, and then as the train was left the place, so he reached at late night at the Sirsa. Then on that, this person was arrested from the Air Force barrack on August 13, 1968. And the accomplice, who was also in the Air Force with Mr. Ravinder Kumar accused, he became the approver. Uh, and now on the prosecution, there are the one is the approver, this witness, and the lady doctor who attended the wife when she was thrown back and admitted to the hospital, the ticket collector who uh, caught this person without the ticket, and some other person also. The story of the defense was that my wife was coming after me, and she was wearing the heavy jewelry, and so someone uh, killed him because of that jewelry and throw from the running train. Now the questions that reach to the court is that about the testimony of the approver, whether the approver testimony is corroborated or not corroborated in the material particular. And on that, this question reached, then the sum of the discussion you will find on the para number 12. And what the para number 12 said, that whether it is a rule of prudence or rule of law, that an approver always has to be corroborated. If he has to be corroborated, how much he has to be corroborated? So as I said, he has to be corroborated in material particular. And on that, some lines I'm reading, you have to um, appreciate that. Para number 12 on page number 172, Ravinder Singh case. An approver is most unworthy friend, if at all, and he is having bargained for his immunity, must prove his worthiness for the credibility in the court. This test is fulfilled firstly if story is relates involving him in the crime and appear intrinsically to be natural and probable catalogue of event that had taken place. The story, if given of minute detail, according with reality, is likely to save it from being rejected brevi manu. Secondly, once that hurdle is crossed, the story given by an approver, so far as the accused on the trial is concerned, must implicate him in such a manner as to give rise to the conclusion of guilt beyond reasonable doubt. In rare case, taking into consideration all the factors, circumstances, and situations governing a particular case, conviction based on uncorroborated evidence of an approver confidently held to be true and reliable by the court may be permissible. So it's not that it's always illegal, that because the approval testimony is not corroborated, and even section 133 established that. Ordinarily, however, an approver statement has to be corroborated in material particulars, bridging closely the distance between the crime and the criminal. certain clinching factor of involvement disclosed by an approver appertaining directly to an accused, if reliable by the touchstone of other independent credible evidence, would give to the needed assurance for the acceptance of his testimony on which the conviction is based. And then on the para number 13, that the approver has a constant companion of the accused. He was arrested along with the accused in this case on the 13th August. He was in the police custody till 27th. He was sent to the jail thereafter. He wrote through the jail superintendent to the magistrate on August 29, expressing willingness to give evidence as a Sultani Gawa, king witness, Sarkari Gawa. He was then granted conditional pardon on September 6 and was examined thereafter as a prosecution witness. Every approver come to give evidence in some such manner, seeking to purchase his immunity, and that is why to start he is unreliable person, and the rule of caution means rule of prudence, calling for material corroboration is constantly kept in mind by the court by time worn judicial practice. So these are the some fact कि अक्यूज को अकोम्प्लिस को अक्यूज के साथ 13 अगस्त को अरेस्ट किया. वो दोनों 17 अगस्त तक 14 दिन तक पुलिस कस्टडी में थे. देन 29 अगस्त को ही एक्सप्रेस दैट ही वांट टू बी किंग्स विटनेस, सरकारी गवाह. एंड इन फैक्ट्स में के बेसिस पे देर इज डाउट दैट टू परचेज हिज इम्यूनिटी, वो बाहर आने के लिए हो सकता है वो झूठ बोल रहा हो. और इस सिचुएशन में देर इज द रूल ऑफ प्रूडेंस दैट his testimony has to be corroborated with material witness. So the main question is whether the approver testimony is corroborated in material particular or not. And for that, the court has observed at length the various other witnesses. Para number 14, para number 16, that Miss Sarma PW, who attended the deceased wife, he was also examined, and the accused got down at Bhuboni railway station, missed the train, and therefore had to arrive at Sirsa later in afternoon. That is also corroborated by PW 26. The accused came by train on July 30, 1961, and not on July 29, 1968. This was also established. The accused booked his cycle at Sasni railway station. This was also proved. And, he got his cycle from the Sirsa station. That was also, proved. He took the delivery of the same at the Sirsa railway station. That is proved. Then again, the accused reported that he has the some burn in the acid, because when he killed his wife by throwing acid and then throwing from the train, so there was some accidentally acid on his hand also. So he when he reached to the air force station on the next day, after 2 3 days he approached to the the medical staff that he has bump on his hand because of some acid fall. So all these things is proved materially corroborated. What the accomplice tell the story that how they boarded the train, how he booked the 22 किलो, उस समय 22 किलो चलती थी, वो वहाँ सिसनी से सिरसा तक पहुँचाना है, कैसे कंपार्टमेंट में कहाँ पे किया, कहाँ पे अक्यूज को थ्रो किया, दैट इज आल्सो corroborated. अक्यूज पे एसिड किया, कहाँ कहाँ डाला, दैट इज आल्सो corroborated. So whole story in the material particular is corroborated. So the question from the defense side that अप्रूवर की टेस्टिमनी एंड अप्रूवर टेस्टिमनी वो पूरी तरह से corroborated नहीं है, so the benefit of the doubt has to be given to the accused. And after analyzing the law on the accomplice in the para number 14 and 16, the court has examined that there is sufficient material corroboration, and on that, in the finally on the para number 21 also you have to read on the para number 23. The court said that we have considered the case both from the both standpoint, that whether High Court was right in interfering with the acquittal, and also whether we should be justified to take the same view as the High Court after examination of evidence if fresh. In addition to to what we have found above, if the accused came in the train with his wife on the date in the question, about which we have not the slightest doubt, his subsequent conduct is true, the tale of his guilty mind, we are absolutely satisfied that accused has been rightly convicted by the High Court, and in the result of that, the appeal fails. So the accomplice testimony is corroborated in the material particulars with the testimony of the other witnesses, and so the conviction is proper. Conviction is from the rule of prudence is also proper. Now there are two more cases. One is Babuni Sahu, and this is the important case. Babuni Sahu versus the King, because it was from the Privy Council, AIR 1949, Privy Council 257. Again, there is the question before the Privy Council is that whether what are the evidences before the Privy Council, and in light of that, whether evidences these evidences corroborate the testimony of the accomplice or not. If you see the evidences on the para number 3 of this case, Babuni Sahu versus the King, the evidence against the appellant, that means this Babuni Sahu who is the accused, the evidence of Kholi Behra, that accomplice, Kholi Behra जिसने offense में participate किया and later on became the prover, so he took part in the murder. Confession of another person, Trinath, recorded under section 164. Recovery of loin cloth, जो धोती जो होती है जो लोग पहनते हैं नीचे उसका कपड़ा, on which deceased was wearing when he was assaulted by the कांति बड़ी इंस्ट्रूमेंट जिससे किसान लोग कुछ काटते हैं. And these are the some of the evidences against the accused. Now if you see the facts, that on the 11th October 1946, one Kalia Behra was brutally murdered at a place between Behrampur, where he lived and carried the business of Jutka driver, and Golantra, to which he was driving with passenger in his Jutka. It is unnecessary to refer the detail of the murder, though it may be noted that the motive attributed to the appellant was that he is in the relation to accused 1 and 2, who are said to have been term of enmity. So Mr. Babuni Sahu have the enmity with the Kalia Behra, and the Kalia Behra who was in the business of Jutka driver, local Gadi. So they killed this person on the 11th October, and later on his accomplice, Mr. Kholi Behra, become the approver or the accomplice. Now the question before the Privy Council is that in light of these three evidences that are on the prosecution, one is one of the accomplice Trinath confession because he broke down. Another is the Kholi Behra as an approver, his testimony. And third one is that clothes that this victim Kalia Behra was wearing at the time of the commission of offense. On the para number 4, you will find that the law relating to accomplice evidence was same in India as in England, and reading to enactment together, the court of India have held that whilst it is not illegal to act upon the uncorroborated evidence of an accomplice, it is rule of prudence so universally followed as to amount almost to a rule of law that is unsafe to act on evidence of an accomplice unless it is corroborated in material respect so as to implicate the accused. And the further that the evidence of one of the accomplice cannot be used to corroborate the evidence of another accomplice. The law in the India thereby substantially the same. Now the question is that one portion is that the Trinath confession may be corroboration, but it was rejected because the confession who was who that person is no long after that this person was died Trinath. So the confession of a person cannot be corroborated to the because confession of that person who already died, and so that would not be proper corroboration. And so the question comes that in that situation whether the accused would get the benefit of the doubt or not. And for that, at the length the discussion happened. Sir Valentine Home did not rely strongly upon the pieces of alleged corroboration. He concentrated his argument mainly on the contention that High Court was wrong in accepting the confession of Trinath as sufficient corroboration of evidence of the approver. This involved consideration of the position of the confession of co-accused under the law, because the confession of the co-accused in itself, I think, if you remember, is a very weak type of the evidence. And when this confession evidence itself need the corroboration, when the one evidence need the corroboration, it cannot be used to corroborate the other evidence that need the corroboration. And so on the page para number 9, that it is not required to, because why? Because the confession of an co-accused is obviously evidence of very weak type. It does not indeed come within the definition of evidence contained in section 3 of the Evidence Act. It is not required to be given on oath nor in the presence of the accused, and it cannot be tested by the cross examination. And so, you know, this testimony this sorry confession of Trinath as an co-accused would not be sufficient to corroborate the approval testimony. Secondly, when the police on the statement of approver approached to the accused house Babuni Sahu to find out the weapon that used in the offense, the mother of the Babuni Sahu was not cooperating, and later on they recovered the Kanti body, the instrument that used by the agricultural, by which the alleged murder was happened. The Privy Council held that because the approver testimony has not been corroborated, and the argument that it is corroborated by the co-accused confession is not proper, because co-accused confession itself need the corroboration. The confession of the co-accused is a very weak type of the evidence, and the fact that the mother of the accused was not cooperating while the police authorities approached to their house. And the second thing is finding out the Kanti body, that is a common instrument in every agricultural farmer, is also not a sufficient evidence. And so the evidence of the accomplice was not corroborated on the material particulars. There are two para also that I'm reading. He may be implicate why a accomplice is unworthy of the credit. The question is not only that because to appease his or to secure his immunity, to appease the prosecution, he tell the story, वो बड़ा चढ़ा के बताता है. But there is another problem, that maybe in the offense there are 4 person, but to just to out of enmity he names 6 more person. Then there would not be any method by which these 6 person can be, separated from 4 accused person. And so on the para number 9, last para, 9, para number 9 also have 3 parts. So in the last part, in some line, there are few lines that are very important. The danger of acting upon accomplice evidence is not merely that the accomplice is on his own admission a man of bad character who took part in the offense, and afterward to save himself betrayed his former associate, and who has placed himself in a position in which he can hardly fail to have a strong bias in favor of prosecution. The real danger is that he is telling a story which, in its general outline, is true, and it is easy for him to work on the story matter which is untrue. He may implicate 10 person in offense, and the story may be true in all detail as to 8 of the person, but untrue as to the other 2, whose name has been introduced because they are the enemies of the approver. This tendency to include the innocent with the guilty is peculiarly prevalent in India, as judges have noted on the innumerable occasion, and it is very difficult for the court to guard against the danger. An Indian village is a seldom in the position to produce the cogent evidence of the alibi. When someone says that this person was also involved in the crime, then it became very difficult, because he cannot take the plea of the alibi, from where he will get the proof that officially he was some other place. And so, if he is charged with having taken plan in the crime on a particular night, when he was in fact asleep in his hut or guarding his crop, he can only rely as a rule on the evidence of his wife, member of his family, or the friends to support his story, and their evidence is interested and not likely to carry out the weight. कहेंगे भाई इसका एविडेंस तो इंटरेस्टेड पार्टी के द्वारा है, परिवार वाले तो कहेंगे. And so it would be very difficult to that person who actually did not take part in the commission of the offense. And so in the last para, on appraisal of these 3 evidences, the court held that in the present case their lordships are complete agreement with the judges of high court in declining to act upon the evidence of the approver, supported only by the confession of the Trinath, that these 2 persons appear to have nothing but hinted assent. They have ample opportunity for repair their statement in concert, and in addition, the prover has sworn to be the contradictory story, and Trinath has denied that his confession was true. It was true that no motive was shown for their falsely implicating the plant, but the motive is often a matter of conjecture. It may be that these 2 men thought too advisable to say falsely that they were acting on the instigation of another rather than on his own initiative, or they may have had reason for their own for wishing to conceal the name of the real instigator. And for the above reason, their lordship are of the opinion that the conviction of the appellant cannot stand. So these are the lines, but if you see that the approver testimony was not corroborated, and the argument that it is corroborated by the confession of the Trinath was rejected, because the confession of the co-accused again need uh, you know uh, corroboration. So one thing that is need corroboration cannot corroborate the another thing, and so with this the conviction cannot stand. The real fear that the privy council has observed, that the real fear is not that this person is unworthy of the credit, and just uh, to appease the authority he is telling the truth and something more than the truth also. But the real danger is that maybe किसी crime में there are 10 person, he named the 10 person, and the story is true with respect to the 8 person, and two-person name he involved because he has the enmities with these two-person. Now there would be no scope for these two-person to prove that they were not guilty, because in the villages, Indian villages, these two-person cannot take the plea of alibi also under section 11. क्या प्रूव करेंगे कि वो अपने क्रॉप को सो रहे कर रहे थे या अपनी झोपड़ी में सो रहे थे, और उनका एविडेंस कौन देगा? उनका एविडेंस उनके परिवार वाले देंगे, एंड इट विल बी कंसीडर्ड दैट दे आर द इंटरेस्टेड विटनेस, एंड वो कोई वेट कैरी नहीं करेंगे. थर्ड केस इस कैटेगरी में आता है हरून हाजी अब्दुल्ला वर्सेस स्टेट ऑफ महाराष्ट्र. Harin Haji Abdulla versus State of Maharashtra, AIR 1968, Supreme Court 832. The found that it is a good business to India. So उन्होंने 3-4 चक्कर में मिडिल ईस्ट से they has to use the gold, and then to enter the India through the water boundary. On the para number 2, you will find this, that several accused was said to be consulted in a criminal conspiracy, the object of which was to smuggle gold in India from the Middle East. The gold was brought in a steam launcher from the places of Persian Gulf and transshipped into Indian boat standing out a sea, which would then sold to taken back to the person waiting for it. The operation was organized by accused number 15 Haji Satar and his nephew number 9 Ayub. And it's Haji Satar and Ayub in the round. In the third round, Haroon Haji Abdulla was also participated. Now, when on the fourth round, the last round, the police authorities has caught this person and want to prosecute, they converted some of the accused into accomplice, as an approver, as an accomplice. Now the question was whether the evidence of the accomplice with respect to Haroon Haji Abdullah is sufficient to convict that person, Haroon Haji Abdullah, or not. And in that case, the only question who were in the conspiracy beside those caught in the spot, the argument in this appeal is there is no legal evidence to connect the Haroon Haji Abdullah with the other accused, and there is only the testimony of the approver. So the question before the court that reached to the Supreme Court is that whether there are sufficient evidence along with the approver that corroborate in the material particular to the testimony, like in the Babuni Sahu, there is no evidence that can corroborate materially, and so the conviction was withheld. So here, yes, here on the para number 4, the case against Mr. Haroon Haji Abdullah, who is the appellant, stand mainly on the basis of the statement of accomplice Kasinath. Kasinath must be held to be a competent witness in view of our decision. So the main evidence is this, and after that, the statement are not confession proper, to which the section 30, the para 4 you can read in the detail. Secondly, the Bengali and the Nur Muhammad, who absconded the trial and finally concluded against him, their statement are not persons jointly tried with the Haroon. Thirdly, a confession of co-accused is not better than the accomplice. And the fourthly, as these confession was later retracted and their probability value is nil. Fifth, the Kasinath's previous statement cannot be used to corroborate him as an accomplice. So if you see the evidences against the Haroon, first is the testimony of the accomplice Kasinath. And the ground that the Kasinath testimony has to be corroborated. The prosecution said that the earlier statement of the Kasinath is corroborating the Kasinath testimony. Second is that the confession of the co-accused, and only on these grounds the Haroon has made following point that my confession cannot stand because of five things. First is that the statement are not confession proper to which section 30 of the Evidence Act can be made applicable. Second, because under section 30 there are certain conditions, only then the co-accused confession will be used against the person. They are on the trial on the same offense, etc. Second is the Bengali and Noor Muhammad that were, treated as the on the trial, they absconded, so they are not on the trial. Third is that the confession of the co-accused is no better than the accomplice. So the confession, as in the Babuni Sahu also we held that the confession cannot corroborate. The fourth one is that confession also, even if you see corroborate, वो बाद में retracted हैं, so उनकी probability value खत्म हो जाती है. Fifth one is that what you are arguing that the earlier statement of the Kasinath, so that would also not sufficient to corroborate in material particular the accomplice testimony. And so on these grounds, all this appeal is there. Now para number 8 that talk about, and it is one of the important para, that the statement of the Bengali, another person who was involved in this smuggling incident, the statement of Bengali being relevant, we have next to see how far it can be held to be legal corroboration of the Kasinath accomplice evidence. The law as to the accomplice evidence is well settled. The Evidence Act in Section 133 provides that an accomplice is a competent witness against the accused person, and that the conviction is not merely is not illegal merely because it proceeds on the uncorroborated testimony of the accomplice. The effect of this provision is that the court trying an accused may legally convict him on the single evidence to an accomplice. To this, there is a rider in the illustration B of the section 114 of the Act, which provides that the court may presume that an accomplice is unworthy of the credit unless he is corroborated in material particular. This cautionary provision incorporate a rule of the prudence, because an accomplice who betrays his associate is not a fair witness, and it is not possible that he may, to please the prosecution, weave a false detail into those which are true, and his whole story appearing the true. There may be no means at the hand to sever the false from the true. It is for this reason that the court, before they act on the accomplice evidence, in some corroboration in material respect to the offense itself, and also the implicating in some satisfactory way, however small, each accused named by the accomplice. In this way, the commission of the offense is confirmed by some competent evidence other than the single or unconfirmed testimony of the accomplice, and the inclusion by the accomplice of an innocent person is defeated. The rule of the caution of the prudence has become so ingrained in the consideration of an accomplice evidence as to have almost the standing of the rule of law. ये रूल ऑफ प्रूडेंस इतना तरह से ingrained हो गया है कि this became as a rule of the law also. But then also, in the strict sense, we cannot say it is the rule of law. And so, this testimony of the approver Kasinath was observed, whether it is corroborated or not corroborated. Kasinath की testimony के अलावा को accused की confession है, co-accused की confession है, जो co-accused है वो भी retracted है, and he's another co-accused is absconding, so they are not on the joint trial also. Previous statement, so that cannot be also corroborating. And so in later on the para number 13, all these facts were then examined. The offense in this case was detected on the night of August 13, 1961, and the investigation went till the morning 14th. Thereafter, the custom authorities served notice upon the various suspects and recovered their statement answer to these notices. The statement of Kasinath and Bengali was recorded on the 15th, and the former by the Karnik and the latter by Rane, the police officers, the authorities. These statements were recorded simultaneously or almost simultaneously. The statement of Noor Ahmad was recorded by the Randi on August 19, as there was no gap of the time between the statement, the Kasinath and Bengali, and the incident was only of the few hours. It is impossible that the officer could have tutored him to make the statement, which agrees in many details. Both the statement receive corroboration at the numerous point in the story from other than the accomplice evidence. For example, the statement of Kasinath regarding the boat employed, the name of the owner and the pilot, the manner of the trip were made, name of the person who took part and what they did, the description of the residence of the Muslim co-accused, the furniture and the furnishing of the room where gold used to be secreted, the description of car employed, the identity of several participants other than Haroon are amply borne out of the evidence, which is not an accomplice in character. A bare reading of the statement of Kasinath made before the court and corroborated by his earlier statement of the custom authorities leaves one convinced that he is speaking the truth. We are not seeking corroboration of the accomplice from his own statement, because that does not advance accomplice evidence any further. We are only looking into the previous statement to see if it disclose any variation which would be put further to the inquiry. The real check come into the compare the two statement which was made by the Bengali. The remarkable degree of agreement is found in also, and in fact they are consistent with the Nuruddin Ahmad sought to make a point and said that they are the result of the collision. Apart from the fact there is no time to collude. And so, in light of this thing, High Court has very searchingly examined the evidence of Kasinath and applied to it by checks, and almost always applied to accomplice evidence before it accepted. Therefore, the corroboration of the evidence of Kasinath in respect of Haroon from the confession of Bengali given independently and in circumstances which exclude any collusion or malpractice regarding this head to provision of section, we do not think that we should interfere in this appeal by the special leave, particularly as we hold the same opinion about the veracity of the Kasina. उन्होंने कहा कि हम corroborate नहीं कर रहे हैं, we are not corroborating from the earlier statement of the Kasina. But if you see the particular, the Kasinath statement and the Bengali statement both are recorded, so there is no possibility that it has to be tutored. And now this thing you can separate out from the Ravinder Singh case. In Ravinder Singh case, the accomplice was living with the accused with 14 days, and then later after 2 days, he want to be paying an approval. Here, both the Bengali and the Kasinath are simultaneously giving the statement, and just to check the veracity. At the one side, the court is saying that yes, from the rule of prudence, it is so ingrained that it became the rule of the law. But then also, because the para number 13 has clearly said that there is no doubt about the whole story, how identification, the car, how the all these things happened, and so there is no doubt about the veracity of the Kasi statement. The ground that you are relying on the earlier statement, that is not true. We are just checking is that there any variation or we need inquiry also. And so with that, the court observed that at this in light of these facts, there is no fear that we interfere, and so the appeal was dismissed, conviction was upheld. Okay. So from these three cases, the true position with respect to the testimony of the accomplices, we find out. If we conclude, we can say that the testimony of the accomplice can be the sole basis of the conviction. As such, there is no rule of law. It is not illegality, but the rule of prudence require that it has to be corroborated with the some independent evidence in the material particular. But when there is no such doubt, and the veracity of the approver is not doubted, in that situation, even without uncorroboration, the conviction can be held and it will not be illegal, because section 133 says that. Now come to the next chapter, and this is the last chapter. There is only one case. We will finish it in the half an hour. The section presumptions. Yeah. Section 4 that we read: may presume, shall presume, and conclusive presume. May presume is the presumption of the fact, like section 114, etc. The court is not always bound to presume it. Shall presumption is court bound to presume it, like in case when a prosecutor say that she was not consented, it is the court to say that court to presume that she was not consented. And the conclusive proof, the strongest one is the conclusive proof. In the may presume, the court presume it or not to presume it, but when the court presume it, you know, there would be a chance given to the other side to rebut it. In the shall presume, the court has to presume it, but there is possible of rebuttal. And in the conclusive proof, if fact A is proved, then B is presumed conclusively presumed to be proved, and even the rebuttal will not be given. Section 112 that talking about the paternity of the child is about the conclusive proof, and only the rebuttal is possible when there is the that rebuttal that is provided in that thing. Other than that, the court will not allow the the allow the person to adduce the evidence to rebut it. And section 112 is about the paternity. It is, there is a public policy behind it. Birth during the marriage, conclusive proof of legitimacy. So section itself says it is because if there is the questions about the paternity, and the court will allow the child that was born out, within the wedlock, so that person will be branded as a bastard, and his mother as the unchaste woman. And so, to hold the legitimacy as a policy, the conclusive proof has been made. Maybe the biologically the story is different. It says the fact that any person was born during the continuance of the valid marriage between the mother and the man, or within the 280 days after his dissolution, the mother remaining unmarried, shall be the conclusive proof that he is the legitimate son of the man. So, whether this person is the legitimate son or not, the first fact has to be proved. The fact that a person was born from a woman, that she was a married woman. So, it would be proof that he is the son of the person to whom his mother is married. Or after marriage also, if marriage is dissolved, then within 280 days, if he was born and his mother was remain unmarried, that would also make the person to whom his mother was married as the legitimate father, that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. So this is only the situation where the father can show that they have no access, and no access means there is no opportunity of having the sexual intercourse. maybe there is proved ground that the woman is unchaste, woman committed the adultery with number of the person, then also the child that is born within the wedlock, the person to whom this lady is married would be the legitimate father. So biologically maybe it is different. When a person A married to a woman and after 2 months this woman deliver a child, so this is again the child born within the wedlock during the subsistence of the marriage. Biologically, it is not possible. There may be some other person who is the father of this child, but law will conclusively presume that it is conclusive proof when the child is born within the wedlock from a woman that the husband of this woman is the legitimate father of this child. So there is the public policy in it. By section 112 is not changing the biological process, but it is just to public policy to legitimize the person. And here comes the question that when suppose there is a fact, it is proved that the child was born from the wedlock, the father if denied the paternity, he will not be allowed to adduce some other evidences except the non-access, because that is provided within the section 112. So that is the difference between the may presume, shall presume, and the conclusive proof. Now there is very interesting case on it, and you will enjoy it. The name of the case is Goutam Kundu versus State of the West Bengal. What happened in this case, that the facts are simple, that the Goutam Kundu married to a woman on the 16th January 1990. And after the from Hindu rites and custom, they lived together for some time. And after that, the wife left for the preparation of higher secondary examination, and these higher secondary examination has to be held on the 5th of April 1990 to 10th of May 1990. In the month of April, when she was not with this man, she conceived a child. She got pregnant. And then the Gautam Kundu said that they did not want this child and to abort, but she delivered a child and it was a baby girl. Then without the consent, if this happened, there was the whole problem in the house, and so therefore she forced to undergo the yeah, during just so she came back to the matrimonial home in the Durga Puja in the October 1990, and there she delivered the child. Then she filed a case for the maintenance of himself and her baby child. This lady of this wife of the Gautam Kundu, she filed maintenance under section 125 of the CRPC. In the proceeding, the this person, he did not want to pay the money to the to the child specially, and so he requested that blood test has to be done. अभी जो DNA टेस्ट होता है कि blood test करवाओ, because I am not the father of this child, and why should I pay money? Why I should pay that maintenance to the for the child? And his application was dismissed. His application was dismissed on the two ground that there is other method of the evidence to disprove the paternity, and moreover it is settled law that medical test cannot be the conclusive proof of the paternity. So he approached to the High Court, and in the High Court it was held that the section 112 of the Evidence Act does not allow such type of the blood testing. It allow because it is a conclusive proof. The only non-access you can prove that there was no opportunity of having sexual intercourse. and that he cannot prove because the wife was only at her home. So you cannot say that he cannot go there and have the sexual intercourse. And so the section 112 is in the problem. Then on the his revision was dismissed by High Court, and so the approach to the Supreme Court. Before the Supreme Court, the argument the forwarded from the Goutam Kundu side is that blood testing is one of the correct test, and in the many cases it can be proved up to the some percentage. The Family Reform Act 1969 conferred power on the court to direct taking the blood test in the civil proceeding case. So this is about not about India, it's about England law where the blood testing is allowed. So all the grounds that in the England there is the court can allow the blood testing, etc. They have argued, and you can find all these in para number 8, 12, etc. And then on the para number 15, that in the India there is no special statute governing the blood test. Neither the Criminal Procedure Code nor the Evidence Act empower the court to direct a such test to be made. The medical jurisprudence and taxonomy and other medical Taylor's principle and practice of medical jurisprudence, all these arguments were made that by blood testing it can be found that whether he is the father of that child or not child. But the real legal question that is before us, that is whether in light of the section 112, whether it can be allowed to the father to disprove the paternity by adducing some evidences, that is of the blood group. The second thing is that blood group testing, for that a person has to be consent. If the women and her child, the wife of Goutam Kundu and the child was not uh, does not want to give their blood group, can court direct. And the third thing is, if they direct, can a adverse inference can be made कि they are not direct, they are not giving the sample, so maybe she is not child of it. And for that, on the para number 21, the beautiful discussion of the Supreme Court about the law with respect to the paternity, prescribed in section 112 of the Evidence Act. The above is the dicta laid down by the various high courts. In matter of this kind, the court must have regard to section 112 of Evidence Act. This section is based on the well-known maxim pater est quem nocte demonstrat. Sometime examiner may ask this maxim and then has to explain with respect to the case law also. So इसका मतलब है he is the father whom the marriage indicate. The presumption of the legitimacy is that the child born of a married woman is deemed to be the legitimate. It throws on the person who is interested in making out the illegitimacy the whole burden of proving that he was not the legitimate child. And the law presumes both the marriage ceremony is a valid and that every child is a legitimate. Marriage or the filiation, parentage, may be presumed, the law in general presuming against vice and the morality. It is a rebuttable presumption. Rebuttable presumption, as I said, it is not rebuttable. But the rebuttable only in the light that the non-excess if has to be proved in only on that it has to be rebutted. Otherwise, the court will not allow to give any evidences. Like in this case, finally, court did not allow to the blood testing to rebut that he is not the father of that girl child. The presumption can only be displaced by strong preponderance of evidence and not by mere balance of the probability. So even it is rebuttable, it has to be proved by the strong evidences, by strong preponderance, like in the criminal case, beyond the reasonable doubt. Yeah. Then on next para 23, taken the conclusive proof that he is the legitimate son of that man unless it can be shown that the party to the marriage had no access to each other at any time when he have been begotten. This rule of law based on the dictate of justice has always been made the court inclined toward upholding the legitimacy of child unless the facts are so compulsive and clinching as to necessarily warrant the finding of child could not at all have been begotten to the father as a result. As such, the legitimate of the child would result in rank injustice to the father. Court always desisted from lightly and hastily rendering it verdict, and that is true on the basis of the slender material, which will be effect branding a child as a bastard and mother as unjust woman. So the direction that is from the case Srimati Dr. Jahan versus Muhammad Farooq, AIR 1987. Earlier Supreme Court has observed that it should not be on the slender evidences because what would be the result? The result would be the child would be declared as a bastard and his mother was an unchaste woman. And then on the para number 14, the court applying this law has held that the section require the party disputing the paternity to prove the non-access in order to dispel the presumption. Only the ground on which this presumption can be dispelled is the non-access. Access and non-access mean existence and non-existence of the opportunities of the sexual intercourse. It does not mean that whether they are actively cohabiting or not, but the opportunity of having the sexual intercourse. And to that, the effect of this section is there is the presumption and a very strong one, though it can be rebuttable in the case of the non access. Conclusive proof as laid down in section 4 of the Evidence Act, and from the above discussion it emerged that the court in India cannot order blood test as a matter of course. It is on the para number 26 I'm reading. Second, wherever the application are made for such prayer in order to give roving inquiry, the prayer of blood test cannot be entertained. There must be a strong para-emphasize case that the husband must establish non-access, non-existence of opportunity for sexual intercourse with his wife, and access to order dispels the presumption arising under section 112 of Evidence Act. The court must carefully examine as to what would be the consequence of ordering the blood test, whether it will have effect the branding a child as bastard and the mother as a unchaste woman. The fifth one is no one can compel to give the blood for the analysis. So this was the law that again the Supreme Court held all the issues resolved, and then in light of that, the court said that we find that the purpose of this application that the Goutam Kundu filed is just to avoid the payment of the maintenance without making any ground. And in light of the law declared, you know, clarified, the petition or the prayer for blood test cannot be allowed. Only he can allowed is to prove the non-access, but he is not proving that non-access, and in that case, this presumption is not rebuttable. It cannot be rebutted only by arguing this one. And when the women deny such blood testing, no adverse inference cannot be made against her. So this is on the section 112. Now there are some other section also that you must read, and this is section 113, section 113A, section 113B, section 114, section 114A, and section 105 and 41. So these 5 6 sections also you may read. As such, the question is not asked, but as a student you must be aware. So the presumption, the three presumption that we have discussed, the may presume, shall presume, and the conclusive proof, their value. Then the the certain sections like the section 41 is also about the conclusive proof it talk about. And the paternity section, section 112, and the case of Goutam Kundu versus the state of West Bengal, we have finally discussed. And the Supreme Court got the opportunity in that case. Section 41, Section 105, Section 113, 114, 114A, etc. These sections you have to read yourself. With this, today class is over, and with this, we have covered the whole syllabus. Now, if you have any question, you can ask me. And before the leaving that, after that, this class, there will be no class from my side. But if you have any question, clarification, or want the lecture, so you can inform through the CR. We can arrange more lecture also before your examination. So with this, my part is over. Now it's on you to ask any questions from today's discussion that you need.